So this video is going to give you a really good overall example about how a typical family can use estate planning and trust to protect what they have for themselves, for their family, making it simple for everybody involved. I made an example. Let's walk through it one step at a time. So, all right. So what I want to go over first is a hypothetical couple called the Simpsons. And what the Simpsons did was they did some estate planning, and their goals were to protect what they had. They didn't want any outside forces coming in and taking what they had. They wanted to avoid probate, make it easy. They wanted to preserve things for themselves, ultimately for their 3 children. They wanted to make sure all the taxes were addressed the right way. Let's take a look. Okay, so Mr. and Mrs. Simpson, they after they finished their estate planning, they still owned some things in their name. They had a checking account with about $20,000. These numbers can vary and will vary from family to family, but I had to put something up there. They have a checking account in their name with $20,000. They have an IRA, and let's say it's in Mr. Simpson's name, and it's worth $80,000, and they have a vehicle. And after we got everything set up, they had what I'll call the Smith Family Irrevocable Trust, and that's designed to protect assets and make sure those assets ultimately go to the children. So in the trust was a savings account with $50,000 in it. There was a CD titled in the name of the Smith Family Irrevocable Trust. It was worth $150,000. They have their home worth $200,000, and they have a brokerage account worth $100,000. Now, every trust has 3 parties to it. It has a trustee or trustees. It has income beneficiaries, and it has principal beneficiaries. So in this case, in their trust, they designated that the Simpsons themselves would be what's called the income beneficiaries. So any income that these assets generated went straight back to the Simpsons checking account. So the interest from the CDs and the savings, the dividends that were produced, or interest from the brokerage account, since they were the income beneficiaries, that went right back to the Simpsons. And because they did retain that income for the rest of their life, it caused the trust to be what's called a Grantor Trust. So even though it was an irrevocable trust, because they retained the income, and perhaps they retained some other powers that caused the trust to be a Grantor Trust, all income was simply just taxed to the Simpsons. It went to the Simpsons, and they just reported it on their personal return. The trust didn't have to file a tax return. Okay, so the trust was a Grantor Trust. All income went to the Simpsons. And of course, way over here, the Simpsons, like most people, they have some pension income. They have some Social Security income. Of course, that all was payable to the Simpsons. That also went into their checking account. So they were able to live and plan to live comfortably out of their income, their pension, their Social Security, their investment income. That's what they used to live off of. In addition, they since they were older than 70 and a half, they had some required distributions from their IRA, and so that supplemented their income as well. Okay, so that's the Grantor Trust provision. Next, I want to talk about the asset protection provisions. So again, the whole idea of creating the trust was to have assets that were protected. And when you talk to your attorney, you can talk about what those assets are protected from. Some attorneys use, creditors, predators. So when you talk to your estate planning attorney, there's many protections that you get from having your assets in an irrevocable trust rather than just leaving them in your name. So you can talk to your attorney about that. So that's the asset protection aspect of transferring assets to an irrevocable trust. Next, I want to talk about, well, what if their home needs to be sold? What if they want to move? What if they have brokerage account assets that need to be sold and reinvested? So when trust assets need to be sold, the trustee or co-trustees, maybe it's the Simpsons, maybe it's one of their children, maybe it's somebody else who's the trustee of their trust. their trustee would simply sell their home, and if their home was worth $200,000, then that check, when they go to the closing, would be payable to the trust, and now there'd be, perhaps $250,000 of savings in the trust, and that home would be sold. And then perhaps they'd want to buy another home. Well, then the trustee of their trust, let's say they wanted to buy a new home for $250,000. Well, they could use the trust assets and have the trust purchase a new home. So all that buying and selling would be done within their trust. If they needed to reinvest or sell brokerage account assets, maybe they're getting older, they wanted to be more conservative. Of course, the trustee can sell brokerage account assets, reinvest them in the trust account. And again, all that's just done within the trust. Nothing's taken out of the trust or needs to be taken out of the trust. It's all done within the trust. So that's the sale and subsequent repurchase of assets that are in a trust, all done within the trust. The next component that I want to get into is what if the Simpsons say, well, we need more money. We want to take a trip around the world. We are going to need $30,000 out of our trust because we want to go spend it. So most of these trusts say that the Simpsons don't have the right to transfer assets directly from the trust straight into the Simpsons' name. If they had that right to just pull assets out of the trust and just put it directly back into their name, then all those protections that they have wouldn't be there. So what is often said in these trusts is that any distributions out of the trust must go to one of what I'll call the principal beneficiaries, one or all of the principal beneficiaries, and it all depends on the way these trusts are prepared. So anything that comes out of the trust, it can't go to the Simpsons. It must go to one or more of the principal beneficiaries. The Simpsons have 3 children. They are what's called the principal beneficiaries of the trust. They're the ones who are going to get the trust assets when the Simpsons die. That's when the trust ends. And so if the Simpsons need $30,000 out of their trust, then the trustee, whoever that might be, will make a distribution out of the trust, perhaps $30,000, to, let's call it, child number 1. And then once that $30,000 is distributed to child number 1, then that child number 1 can do whatever he or she wants to do with that $30,000. They could spend it on their parents. They could give it back to their parents. So, but any distribution from the trust, typically these trusts are arranged where it can't go straight to the Simpsons, but it can go to one or more of the principal beneficiaries. You might be asking, are there any tax consequences to that? So let me give you the short and long answer. In 2018, someone can give $15,000 to as many people as they want to without incurring any gift tax consequences. Well, if this is a grantor trust, then the Simpsons are, by making a distribution from this trust, they're each, Mr. and Mrs. Simpson are each giving $15,000 to child number 1. And so that fits within this $15,000. But let's take an example. Let's make it worse, or what appears to be worse for tax consequences. Let's say Mr. Simpson made a taxable gift of $115,000, or made a gift of $115,000, or a distribution from the trust to child number 1, $115,000. That's a heck of a lot more than $15,000. In fact, it's $100,000 more. Who owes tax? Nobody does. Really, what Mr. Simpson did by giving his child $115,000. The first $15,000 doesn't count. That extra $100,000, Mr. Simpson has an $11.2 million estate tax exemption by giving his child, or making a distribution to his child, of $115,000. First 15 doesn't count. He made a $100,000 taxable gift. Nobody owes any tax. Mr. Simpson just used $100,000 of his $11.2 million exemption. Now when Mr. Simpson dies, he can only leave $11.1 million to his heirs free of estate tax. He doesn't have anywhere near that much. It's a non-issue. However, if he made that large a gift, he's supposed to report it on a gift tax return, IRS Form 709. That's due on April 15th of the year following when the gift was made. So a bunch of tax talk to show you that there's no tax due on these distributions, even if they're considered a taxable gift. People are just using up some of the $11.2 million exemption that they'll never use anyway. Okay, so that's the distribution of cash or other assets from the trust to one or more of the children, and then once the children get it, they can do whatever they want to with it, and perhaps they want to give it back to their parent or spend it on their parent. Okay, and then the last item here is the probate avoidance piece, and let's talk through that, because let's say now Mr. and Mrs. Simpson pass away. What happens? Well, we have to look at the assets in Mr. and Mrs. Simpson's name, and we have to look at the assets in the trust. Let's go through the assets that are in Mr. and Mrs. Simpson's name. They have a checking account. Perhaps they arranged that account so it wouldn't be frozen when they passed away. Maybe a child has signature authority, or there's a POD designation, so that doesn't have to go through probate. They'll have beneficiary designations on their IRA. That doesn't go through probate. In fact, here in Louisiana, it's easy if you set things up right to transfer a vehicle when you pass away without having to go through probate. So that stuff avoids all the probate. But then you've got all these other things, but they're titled in the name of a trust. Things in a trust don't have to go through probate. The Smiths likely named someone to be the trustee after the Simpsons died. Let's say they named child number one. Then when the Simpsons pass away, child number one, who is that trustee when the Smiths die, will have access to all of these trust assets, and child number one will be able to terminate the trust and disperse everything out of the trust to the three children, perhaps equally if that's what they stated in the trust instrument, without having to go through lawyers and probate proceedings and courts and judges and dealing with frozen accounts and all that you have to, and all the expense and hassle and delay of dealing with that. So there you have it. This is just a really good, kind of a typical example of kind of a middle-class family. They've worked hard, they've saved, now they're in protection and preservation mode. They realize there's some things that can happen in the rest of their lives that could cause them to lose what they have. So in a timely manner, they set all this up. Things in their trust are protected, and all these benefits are recognized, from the asset protection to the probate avoidance to the grantor trust provisions, making it simple to keep what they have and pass it along to their family. So I do have to caution you, every family is unique, every set of circumstances is unique, every state has their own unique laws regarding probate and state income tax and Medicaid eligibility and protection from lawsuits. So don't take this information and run and try to do it with yourself. Make sure you work with the right attorney in your area who can guide you through this the right way. And but it really can be powerful and really can give you some peace of mind knowing that everything's protected for yourself and your family. I'm Paul Rabelais. Now go out there and leave a legacy. Take care.